Welcome. Today we have a very special guest, and we're very lucky uh, to have him. He's been here before. Julian Raven, who is very modest, so he does not want to take any credit for any of the controversy swirling around the Smithsonian. But I joke to him, he's a little like Harriet Beecher Stowe. He's the gentleman who started this war. And he had this lawsuit against the Smithsonian, and he has some updates to share with us that resulted in the Trump administration forcing out the director of the National Portrait Gallery, who had rejected Julian Raven's portrait of Donald Trump in the days he was a Trump supporter, although now he's no longer a Trump supporter. But I think you're still a critic of the Smithsonian, but you have a different perspective. And so now he's suing the Smithsonian, and he has some updates. He may be suing President Trump as well. So, Julian, why don't you tell us what's exactly going on with your lawsuit in the Smithsonian case?
I will be glad to, Larry. Good morning, and thanks for having me on again. And yeah, it's so fascinating to me at the moment because there are so many sides to what I am seeing and am participating in that it's constantly drawing my attention and drawing my curiosity and looking always for a solution. That's the way I am wired. I'm always looking to see how this thing can be fixed, made right, and function the way it was originally designed. The thing with Trump right now for me, and which is interesting, is that even though personally I do not and I cannot support him, much of what his policies are doing, I support wholeheartedly. I mean, that's what the whole point was in the beginning. And I've seen it develop over the last 9 years, since, or 10 years, sorry, 2015, exactly what my painting predicted. The vision in the painting, were you to really get an interpretive understanding of the symbolism, was this making America great again. This vision, the way that I painted the image, even as this, it was like waves that were depicted as stripes in the American flag coming out the side of Trump's head. Like, this is the vision of him remaking America. And there were the new stars and the new stripes and the new ink, all part of the refashioning of the faded, torn flag, which was also part of the painting. So, this is what was the picture from 2015. My personally, right now, I pray for President Trump. There's no animosity against the man. I pray that the great conversion that I believed at the beginning in that is woven into the content of that painting will take place. That the greatest effect on mankind that this man could have is when he genuinely bows the knee before the living God of the universe and gives his life genuinely over, and that through Christ he is converted, and that change becomes a visible demonstration of a man's life that is radically changed by the power of God to become something that he's not right now. Now, moving on from that, though, we get into all of his foibles, et cetera, et cetera. So that's my sort of position on the president right now. Now, regarding the Smithsonian, for whatever reason, providence or destiny, this has landed in my lap. And as much as I've tried to walk away from it, even my foray in Spain, that I did not want anything to do with it ever again. It was such a grief to me and a burden. It was so many years and so much heartache and disappointment that I'm like, I want nothing. And this was like 5 months ago in the beach of Spain, 4 a.m, looking up at the stars. And yet, within a few months, I'm back in the US, and the president tries to fire Kim Sayet, and the whole thing comes front and center once again. And it's never been so in focus as it is now. It's remarkable, Larry. So, as you know, because I get those emails from you, as you can see this attention, it's remarkable. So, what do we want? What do I want? What do we want as Americans? And as I've been put in this one little sliver, this little battle, um, somebody who loves the truth, who loves righteousness and justice, and I want to see just things be true to what they were intended to be. I then have been dropped into this little battle that I'm fighting to see that happen with the Smithsonian. And my case against them of late, my third case, was born out of what the president did. You see, he poked the bear, needed, and he did his attempt to fire Kim Sayet although unlawful, but in spirit, as I said, it was what was needed to happen because no one else was going to push the envelope. This is, I think, one of Trump's greatest gifts, that he's able, as you said at the beginning, to just rattle the status quo because he's just sticks his finger right in there. And that was great. And, there's kudos to the president for doing that. The problem becomes then what follows after that. So he caused this domino effect with trying to fire Kim Sayed, and then what happened afterwards when it provoked the comments from the Board of Regents and the secretary saying, "Oh, well, we're independent. Firing and hiring is our job." Rebuffing the president, and then Kim Sayed resigning the next week, and then Lonnie Bunch coming out and saying he tacitly basically admits that they have been partisan in some of their dealings and decisions. He didn't say which, he didn't say to whom. And I meditated on that for a few weeks, and I'm like, hold on a second. He's admitting to everything that I sued them for. And then, hold on, the president said, yes, she's highly partisan. He's quoting verbatim what Judge McFadden said in 2018 when he called her partisan and odious. The response to the Smithsonian was silence. They never dealt with it. It came out in that New York Times article that came out about 3 weeks ago. They had insider information from that meeting with John Roberts. John Roberts defended her again when the congressman tried to have her. He said, well, why don't we just fire her? And John Roberts just like, so I'm like, hold on a second. It's now certified from the president of the United States that this woman is partisan. They've defended her for 8 years. The judge said she was partisan back in 2018. They did nothing about it. They kicked me to the street, and they keep a partisan actor inside the Smithsonian for all these years, all of them. And so they're complicit in what I have concluded without a shadow of a doubt, from my opinion, is that they have breached their fiduciary duties. Of one of the duties, obviously, is duty of care, duty of loyalty to the trust of James Smithson, and the duty of impartiality. It's a codified duty in the trust laws of Washington, D.C., and they have violated that. So it was my grounds into saying, I'm going to sue them now again for this breach of trust because they have now been found caught red-handed that they kept this partisan actor in her job when all these officials have stated she's partisan, and they kept her there. And Roberts is even defending her to the last minute, it appeared, by those comments in the New York Times. So I'm very confident that that aspect of the lawsuit will have a great success. It leads to the other side, Larry, which is now involving Congress and the president. So it's a full-scale legal assault right now that I'm involved in, with the ultimate goal of getting a declaration from the U.S. Supreme Court, finally, that they would state what the Smithsonian is by law and what laws it should abide by. So that's where I am today.
Let me ask you a question. Have you actually filed the paperwork for this?
Oh, it's all done. It's all, I just got they've appointed now, some of the ironies, the U.S. attorneys are defending them. The attorney was appointed 2 days ago. He's asking for more time, but I have, this is
what is your case called? This current case?
Now called Raven versus Roberts, and it's case number 25 CV 02332 TSC. Tanya Chutkan is the attorney. I mean, the judge, the federal judge, that she was very prominent last year and the year before in some of her adjudications of the January 6 insurrectionists. So this is going to be, it's so fascinating. Larry, as Trump is battling and trying to battle the Smithsonian, the DOJ for now is being obligated to defend them. So it's hysterical. They're from every side. It's hysterical.
But let me get something straight. You're actually suing Chief Justice John Roberts, is that right?
As Chancellor of the Smithsonian, correct.
But in the end, the Supreme Court might hear your case.
He'd have to recuse himself again, like he did in 2019. He'd have to step off the bench, and the other 8 justices would have to decide his fate. the ramifications of this lawsuit from me, the nobody outlier, they're so great if it has legs, or they just cut it out from underneath me, because that's what they did the last time. But Judge Chutkin now, she's the quote unquote ideologue, anti-Trump ideologue in the justice system. It's going to be very interesting to see how she rules, because at the same time as Roberts is on the bench, now Lonnie Bunch is on the bench. So then it's like, well, if she stands for me in any way, it's going to cost him, or should she defend him? I mean, it's like a game of chess that I've been playing, that I think now I have moved the pieces in where it will have an impact, because it's unavoidable unless they just burn the documents and put me 6 feet under the ground, type of thing. So we'll see.
Okay, I don't quite understand. So you said you're also suing the president? Is this in this
This is
case?
my amended complaint. Correct. Now the president, Congress, and the principal claims are based on the Smithsonian Institution being the expressed will of a private citizen by the name of James Smithson. It was his last will and testament to create this institution. And Congress in 1846 accepted that charge, or that responsibility, that fiduciary duty, in trust. And they established this private institution that they say clearly in the Act of 1846 that it is the will of the enlightened donor, is what they call him, and that Congress is merely the trustee to follow through and carry out his will. So based upon that the Smithsonian is simply a private charitable trust. That's all it is. It's like a church. It's like a nonprofit. It's all it is, except it's the guardian is the federal government under Congress. The president, by his incursions, reaching across the mall and dabbling in the Smithsonian, is violating the trust, because the president, even Andrew Jackson in the 1830s, when they were debating who could receive this will, who could receive James Smithson's trust, it was determined then that Andrew Jackson, as the executive, could not have or could not receive the testamentary will of James Smithson. It had to come to Congress. They were the only legal body that could accept his will. So the executive was canceled out. So now the president is meddling, coercively meddling into the Smithsonian Institution. And whether or not, we can agree that what he's doing, and I agree with the what he's saying, but it's illegal what he's doing. And so under trust law,
well, let me stop you right there, because I read the White House letter to Lonnie Bunch, and also the other documents, the Restoring Truth and Sanity to American History, March 27, 2025. And there it says, actually, he's working through Vice President Vance, and Vance is a regent of the Smithsonian, and he is allowed to meddle, right?
Right. Well, that would be that's who he is. The question as a private trust, Larry, is this, as I wrote about in my book, is what I firmly believe, according to trust law and everything that I've been studying now for the last 9 years, is that the regents, when John Roberts, when J.D. Vance, when the 3 members of Congress and the 3 members of the Senate sit down at the board of, they take off their proverbial robes and leave them at the front door. And they enter into that board of regents with 9 members of the public, unelected members of the citizenry. They sit down as private citizens of the United States to basically execute the will of a private citizen. There is and should be no government influence on the content of the Smithsonian Institution. James Smithson was a scientist, and although he did not say what the knowledge should be, his will states that he wanted at Washington specifically, by name specifically, the Smithsonian Institution to be established for the increase and diffusion of knowledge among men. It made no mention of the content. So it's up for grabs, which is true. But by law, the Board of Regents should be a non-partisan, non-governmental group of adults of trust. They're actually fiduciary they're not trustees, specifically the Board of Regents. They are those who are sent by the trustees, which is Congress. And their job is to execute the will of James Smithson, not the president's will, and not to say that, hey, we could talk about this or talk about it, fair enough. But there is a bar and a wall of separation between the government and the private nature of this trust that the federal government and the president, by attempting to coerce or manipulate under threat of sanctions or financing, which should never has happened. The Smithsonian should have functioned on its private bequest since the beginning. There was $60 million donated in 1836. $60 million. Then it was $541,000. There's another trust that was created in 1848 in Philadelphia by Girard, also in my book, Larry, which is he gave $6 million to be kept in trust by the government in Pennsylvania, in Philadelphia. And his will has functioned since then and never accepted government monies. It's still running today, and it has always operated on the private bequest that was donated by the Frenchman Girard. In the same way, the Smithsonian should never have accepted appropriations and should have always remained a private trust, free from then government control. That's the problem. There has been this unholy alliance created over time, not through law, not through a dissolution of the trust. It has been created by ignorance, by adrift, by political influence, all of the different mechanisms that have happened that have been illicit. They have not been through law. And that as a result of that, the Smithsonian has finally become this institution funded by the federal government. And this is how funny it is. It was a gift to the American people that should have functioned as a gift to us, who the American people end up paying for. It's crazy.
Let me ask you another question. What are you actually asking for in your lawsuit? What relief? What is the bottom line? What do you want them to do?
I have about 5 motions, preliminary motions filed already with the court. One of them is for injunctive relief against the president, the executive, that and the goal is this, Larry. In 2018, when Judge McFadden made the fictitious ruling that he did, calling the Smithsonian the government through and through, he gave this private charity the full power of the federal government to speak and trample my First Amendment protective speech rights. He said, in order to silence Raven, I'm going to say that the Smithsonian is the government through and through. He quotes no laws. He made it up. He created a legal fiction. Now, that was what I presented to the Supreme Court in 2019 for them to say what the law is. What is the Smithsonian Institution? What laws apply? How does the Constitution apply? Their job was to do that. Now, what happened? Judge Roberts recused himself. The other justices obviously kicked the can down the street. I have tried.
Wait, what did they do? Did they dismiss the case?
They refused to hear it.
Okay.
So when they refused to hear it, they left that unanswered question of federal law in place. Nobody knows. That's why everyone's up in armor. How can the president be doing this? And how can he be doing this? And all this. It would have been answered if they had answered the question in 2019.
Although based on what you said, actually, paradoxically, it was your case with McFadden's ruling that gave a legal basis for the president to act if it's government through and through.
Standing on a straw man. Yeah, you're absolutely right. Yeah, that's exactly. They could say, well, the judge says it's through and through. And then the question for the court would be to say, well, where did he base that on?
But the court didn't overrule him, so it still stands.
It still stands. And
so that's the law.
And that is a law created.
So because of your case, you now have a legal basis for President Trump to do what he's doing.
So because that's one side that they could say, well, the judge made this and the Supreme Court didn't answer it. You could say, well, it's established law, because technically you're absolutely right. The question is the trust aspect of the Smithsonian. This was the part that I found fascinating. The judge refused to acknowledge any of my trust arguments that I leveled against him back in 2018. He said this is the only time that he mentioned, he says, he acknowledges in one sentence, again, without citing any laws, without any type of verifiable basis for what he's saying. He says, the Smithsonian seems to be in private at some time, but Congress ratified it. And this was his legal argument. He makes a fictitious, Congress ratified it? No, they did not. They did no such thing. Congress accepted the will of James Smithson. It says it, they were trustees. Joseph Henry, the remarkable American scientist who built the Smithsonian with his bare hands, basically, he spent 37 years of his life dedicated to building that marvelous institution. He said, and because he knew right at the beginning in the charter of the Smithsonian in 1848, this was ratified by the Board of Regents in 1848, right when the doors of the Smithsonian were going to fling open to the public. He wrote the vision statement, the 10 points that this is what the Smithsonian is. And in the first 2 points, he specifically says, because he knew even back then that the government was trying to meddle in the private trust, he writes, the Smithsonian is not a national establishment. The Smithsonian is the private express will of a private citizen to carry out the will of James Smithson. He writes it in black and white too.
Okay. So
Yeah.
let's go. What are your other
No, so let me finish.
other points in what you're asking for? You gave one.
No, so the point is that I have the basis to go to the judge and say this is not the government through and through. This is a private trust. And yet the motions that I have, the one for injunction relief and also for certification to the Supreme Court. In other words, I found out that I can actually ask the court to certify the question now this is the 4th time to the U.S. Supreme Court to say, we need an explanation what the Smithsonian Institution is. What is the Smithsonian Institution? That was motion number 2. So these preliminary motions are hanging before the case can even go forward to see if Judge Chutkan will say, okay, I see that this is a confusing issue. All of this noise around the president, what he's doing is a confusing issue. Nobody really knows. The president is taking advantage of that, which is what he does. And that's one of his gifts and strengths. He just goes straight in and says, oh, he's going to meddle with it. And then we'll see what happens down the road. So he's provoking the dialogue, which is what needed to happen. But now it needs to be resolved legally at the highest court of the land, where they need to say, well, hold on a second. This is what the Smithsonian is. These are the laws that the Smithsonian should be guided by and guided by. And these are the interventions that can happen. And these are the interventions that cannot happen. So these preliminary motions, I hope and pray that and interestingly, the U.S. attorney, his name is Duffy, who wrote to me 2 days ago, he wanted more time. He asked me because he's motioning for more time. He says he's swamped with cases. He says
they always delay. It's a tactic. Let me ask you a question.
But he's asking on the injunctive relief. He's focusing in on that because I believe that may be the beginning of the resolution that I'm looking for.
Well, it's okay. You've got one for injunctive relief, and you said you have 5 motions. What are the other 4?
The others are just judicial notice on the facts of the Smithsonian Institution, that before we even go forward, that the court acknowledges all of these documents that I filed, which was like the program of organization from 1848, to say, look, this is what Joseph Henry said, and this is what the Board of Regents certified back then. The Smithsonian is not a national institution. It is a private trust. So I want the court to say, yes, these are all certified. These are all documented, real documents, so that we can say right at the beginning, we don't have to argue about this. It's right there.
So, okay, you're stipulating these documents.
The other is a motion to use the electronic filing system as a pro se litigant.
Okay, well,
so it's just little procedural technicalities. So
wait, let me ask you a question. If you're granted this injunctive relief, what happens then?
Then they will issue an order to the president to say, you cannot exercise any more efforts to control or edit or curate the knowledge in the Smithsonian Institution until the U.S. Supreme Court answers this unresolved, unanswered question of federal law.
Which they may never do.
Well, you never know, because if the judge, you see, this is what I found was fascinating. All of my petitions to the Supreme Court have been ignored. There have been 3 of them since 2019. But the judge, by law, can certify the question herself to SCOTUS. And I don't think that they can just ignore that. I think
but she would then have to want to put Chief Justice Roberts on the spot that would be also a decision. That
That's
would, to me,
again,
make
it would
life uncomfortable for
for her
Robin.
because he's technically her boss in a way. And so all of these dynamics are playing out, and it's going to take a judge who's courageous enough to say, this needs to be resolved and we have to get it regardless if it's going to offend
Okay.
Judge Roberts.
So let me go in another direction then. So let's say you win your case. What do you get out of it? What does the Smithsonian get out of it? And what do the American people get out of it?
We're starting with the American people. I think the most important legal aspect is that American citizens will know what they are, that they are the beneficiaries of the Smithson Private Trust. They will know what laws they stand on when they walk through the doors of the Smithsonian Institution. They will know what their rights are as beneficiaries, and not just passive beneficiaries. The Smithsonian Institution is what's called an active and a passive trust. You're not just people that go in there and look at stuff. The Smithsonian Institution, since its founding, was created by the American people. The government was never involved at the beginning. The government never created the content. Basically, what the government did was ensure that Joseph Henry had the money available, which was borrowed, by the way. The $541,000 was borrowed by Congress, and this is another cause of my complaint against Congress. They took the money, they borrowed it immediately, and they paid 6% interest on it annually for the operation of the Smithsonian. The Smithsonian was built with the interest, not with the bequest. That's a side issue and another argument that I have. But the point is that they ensured that the buildings were built. They raised up these wonderful buildings, and they were empty. And then Joseph Henry's job was to say to America, bring us your stuff, bring us your artifacts, bring us your pictures, bring us your this. And it became, from an empty hallway, a building full of stuff from the American people, that it was our stuff going to this institution their job was to sort it out.
Okay, but one of the claims is the stuff is not being sorted out in a good faith manner, that it's being sorted out according to, say, political agendas or propaganda and so forth.
I wouldn't
And that
believe
would not be, propaganda does not equal knowledge. Propaganda is something totally different.
Absolutely.
And if it's been used for propaganda instead of knowledge, it's in violation of the original bequest.
Right. And because the trust law has a law, which is, like I said, the duty of impartiality is one of the binding duties of charitable trusts. And so it's very easy. The president's right what he's saying. My whole lawsuit is, and my battle with this partisan actor, which is just an expression of an institution that has been partisan for years. You're absolutely right. So what I'm asking for in the lawsuit, other than for the American people, is then the 2007 IRC report that was ordered by John Roberts, that was an investigation on the Board of Regents itself, came back from professional nonprofit experts. They concluded the Board of Regents is a joke. It's the worst run thing. Chuck Grassley jumps in. He writes like a bill to modify the Board of Regents. Senator Eleanor Holmes, or Congresswoman Eleanor Holmes, she writes a bill to modify the Smithsonian. I convinced my local congressman in 2022 to put on the floor the Smithsonian modernization bill. All of these to take basically the Board of Regents out of the hands of government officials. They need to dissolve the board. This is one of my requests in the lawsuit, to dissolve the Board of Regents, take it out of the hands of Congress, and follow the advice of this report from 2007, which is basically build a new Board of Regents from nonpartisan people under the supervision, whether of the courts, whether it stays under the supervision of Congress. I don't think that should happen because they've so abdicated their job, their role as trustees. They should have nothing to do with the Smithsonian. They've already blown it. Maybe it should stay in the hands of the court. Maybe the court has another mechanism to appoint a board or a supervisory board that can take care of the implementation of the trust. That's something yet to be discovered. But the solution was already written out.
You would want to have a court supervised reorganization, sort of like a bankruptcy.
Because the courts in equity and since Magna Carta, the courts in Chancery in the United Kingdom, where we're standing on, they have always been the defenders, not just arbiters between two parties. Courts have the specific fiduciary role to defend the testator. Their job is to defend James Smithson more than just adjudicate. They are to stand on the side of the testator. Their job is to execute the trust. And if there are trustees that are failing, their job is to kick them out. Their job is to appoint new trustees. And this is the part you're going to love. This is where the irony is so beautiful, that I paint a portrait of a man in 2015, and then all these years later, you're all about this portrait. I'm in this battle, and here's the same guy, now the president of the United States, poking at the Smithsonian by trust law, Larry. And this is so, I just learned this, and I found it absolutely fascinating. And this is the illustration to help us understand what it is. There is a crime, but it's a civil crime under trust law, which is called a son de tort, French term. And what it basically means is, let's say, someone leaves, a mother leaves a house to a son in trust, and the son butchers the house, and he's smashing it up and mismanaging it, et cetera, and the mother's dead. But then the other brother, who was not a trustee of the property, he sees the abuse, he sees the neglect, and he breaks into the house and he tries to take over the trust. He tries to grab hold of it, to save it, rotting and going into the ground. When that case goes to law, the courts, again, because they have this power over trusts, they can appoint, in what's called a constructive trustee definition, they can appoint that person as the new constructive trustee to actually fulfill the trust and be held accountable to the trust duties. So President Trump, and even in my lawsuit, at the end I said, ironically, it's like now the president himself can be appointed as the constructive trustee of the Smithsonian Institution. He could be the one that finally is placed in a position to make sure the trust executes its role. I mean, it's hysterical, Larry. It's so, but to add,
and he could be appointed to that independent of being president. So when his term ends, he could still be the trustee for the Smithsonian.
You're absolutely right. And this,
so that could be a good job for him after his term is over.
Is over, and
it would be a nice solution. Roberts would be replaced by Trump.
Well,
but I don't think that Judge Chutkan would want that somehow.
No, but again, everyone is being called to make a decision that's going to be uncomfortable for them. The next person, and this is which I've known for years, which I never pulled this trigger back in 2017, 2018, which is this: under trust law, charitable trust law in the District of Delaware, basically, or sorry, the Washington D.C., that there is an individual, an office, who in every state of the United States is the principal legal guardian of the beneficiaries of a public trust when the trust is being breached by the trustees. And I'll give you a shot to have a guess who this is. This is so off the wall for most people, because
I can't guess, so just tell me, please.
I'm going to tell you. No, his name is Brian Schwalb. He is the Washington D.C. Attorney General.
Not
Van Bombay. No, the Attorney General.
Oh, okay.
Washington D.C. He just filed suit against Trump last week for the law enforcement incursion.
Okay.
Washington D.C.
So these are the same cast of characters as Russiagate and everything else. So
no, but listen.
But Schwab would become the.
He is what's called the parens patriae by ancient law. The Attorney General is the defender of the trust and of the beneficiaries of that trust.
So what's his role in this?
So his role in this now is that basically, and I've written to him, and this is where the Washington Post has the story now, and they're on this story, watching it develop. I've written to him last week, informing.
Well, it's a hell of a story.
Informing him, Larry, that hey, Mr. Attorney General for Washington D.C., you are the parens patriae of the private Smithsonian Trust. He's going to be like, because if he had have known, he would have already litigated. Most people don't know this, and he's a new AG since 2023.
Does he have an obligation to do so?
I believe it's a codified obligation. It's right in the DC
So
trust.
once you've notified him, he has to intervene?
He has to intervene. And so yesterday, the Post said to me, well, we're waiting to see what he's going to do. So imagine this. He's in a situation now where and I've asked him to either support my motions for certification and injunctive relief in an amicus brief, that he would just come into my case and say, oh, we agree with Mr. Raven. We should get the Supreme Court. Now, I think that's highly unlikely, because
he could seize control of the Smithsonian himself.
Not seize control. The courts will seize control. He can advocate for the trust to be executed as originally intended on behalf of the beneficiaries, the American people, and specifically the people in Washington, D.C., because the trust was specifically named to be formed in Washington, D.C.
And Trump's letter to Lonnie Bunch, which doesn't show up because of the special effect, but it's behind me, that would be evidence that they are not serving the interests of the American people.
Well, it's evidence of this meddling, which there's wonderful cases that I found that support my claims.
But also the president elected by the American people says you're not serving the American people.
Right.
You're serving some other master.
Right. And he should do that. And he should point the finger, but then he should pull the trigger for the legal mechanism to go into play so that it's done righteously. That's the whole point. So if we're going to be people of the rule of law, then it's like, well, then this needs to follow the rule of law.
But they may not be aware of all of these nuances.
Right.
So the other thing is, you're doing this all by yourself without any wills, trust, and estate lawyers, right?
Yeah,
but there must be, certainly in Washington, because people die all the time, and there are a lot of trusts. There must be some wills, trusts, and estate lawyers who must be salivating.
There are, but the problem is none of them
to get their fingers into this. I mean, you could make a lot of money if you really thought about it, pulling on all sides of it.
It's doing that, but it's until the Supreme Court says, yeah, the Smithsonian is just a private trust. Nobody is going to move, because they're arguing like I am out in the wilderness about something that nobody else is arguing. And it's like, well, it's right there in black and white. I mean, how can you miss it? It's like there's no law that it ever changed.
But let me go on. If it's not a private trust, then President Trump has every right to do whatever he wants with it as chief executive.
Well, then that's another question to be defined, whether or not if the statement that McFadden said, that it's the government through and through, is true, well, then demonstrate that, and demonstrate who is it that has the hands on the levers that can actually tell and dictate what's going on. By law, it's Congress. It's right there in the Congressional Act. You can't go any, it's right there. It's in black and white. So that's why it's this crying out, this question. And now, Larry, this is my fifth move to compel the Supreme Court to answer the unanswered question. And the other option for Attorney General Schwab is that he can file, obviously, directly, which I told him to do, to motion the Supreme Court directly and file a petition and say, what is the Smithsonian Institution, so I can know what my job is and my authority and my role. He then will, by them answering him, will answer me and will undo all this nonsense that McFadden said. It's amazing.
But it's more likely that he'll duck, just like the Supreme Court.
That is a possibility, which I wrote in my legal brief. It's in there, and I have a whole scenario broken down that if he ducks, which he could, I don't believe he could. He might be liable as well or I even thought he might resign. I said the implications that if he does this actually legitimizes Raven.
No one resigns.
No, ever. Well, except say it, right?
So she was forced out.
Well, that I would agree with, but we don't know for sure. It's speculation. I know, but the thing is, Larry, if he doesn't, by law, it's amazing. This is the other amazing part, is that I have two lawsuits, two cases, federal cases. Well, one of them is federal in Washington, D.C., which is Eads Home versus Hooker, which gives me this, because I have to have standing. How can a member of the public bring a breach of trust lawsuit against a private charitable trust?
But wait, are you an American citizen now?
Oh, of course.
Well, then you have standing, right? Because
Well,
it's
no,
for
no,
the
no, but
benefit of American citizens.
right, but this is that by law, individual, you see, trusts, if unless you're named in a trust as an individual, like, Lawrence Jarvik, you're the beneficiary of this trust, you can't litigate. You can't litigate. And yet there are these two provisions in law which I'm standing on. One of them is this: if the attorney general, like in the case in the Supreme Court in Hawaii, in the city of Kapiolani, where there was a park given to the public for the park's benefit that was then corrupted by both the attorney general and the government. They wanted to divert part of the land to build condos on it, and the people were up in arms. The court said, when the attorney general and the government is corrupt and they're all part of the problem, we give standing to the members of the public to come and enforce the trust. So that's number one. If he ducks, like you said. The other standing that I discovered back in 2017, which was one of my hallelujah moments, wrote about it in my book, was this: that the other standing created by a Washington, also a trust in Washington, D.C., also administered by the federal government, which is a home for the elderly, which is called Eads Home. In that law, it was established that unless the person has a special interest in the private charitable trust, they cannot bring a suit against the trustees. And so technically, if you look at, well, this Smithsonian mentions nobody except the American people, mentions the United States of America. But marvelously, in the codified trust created bylaws of the Smithsonian, the National Portrait Gallery specifically says that its existence is for both the subjects of the portraits and for the artists who created them. It's to be used as a legitimizer, or basically a fulcrum to elevate the artist and to give acknowledgement.
Let me stop you right there, because that would give not only you standing as the artist, it would give President Trump standing
as the subject. You're absolutely right.
Because he actually was affected.
You're absolutely right.
Compared to President Obama's shrine that they built there.
You're absolutely right. And Larry, it's lovely to see how sharp you are there, catching those little nuances, because that's exactly, and I thought that through as well. I said, well, he's equally got standing as the subject, while I have standing as the artist.
So he wouldn't have subject as president per se, but as subject of a portrait of a president, he now has standing to meddle and point his finger and complain about the Smithsonian and write these letters. Well, it's not as a president, as a for whatever, but as a subject of work. So what do you say about that?
Well, I am totally in agreement that he should be pointing his finger and meddling, in the sense of doing it as, obviously, the opinion of the president holds huge weight and consequence, and he's not wrong. He's absolutely not wrong. Like I said, my whole case is evidence that it's true. It's like, I wrote an article the other day and I called it "The Deep Stake," about, I'm the farthest thing from a conspiracy minded person, but you hear all these arguments about the deep state and they point to all these different factors, and you're like, well, Kim Sayed, she's like the poster child of the deep state. She was a federal employee who used her position to enforce her political agenda. I mean, that's exactly what was going on, her anti-Trump political agenda.
Wait a minute. I thought you said the trust was not a federal employee, that they were a trustee and trust employees.
But the employees are federal.
They're actually federal. They're not a separate.
No,
they're not like Federal Reserve.
All of the officers of the Smithsonian, they're federal employees. But the regents are volunteers. They don't even get paid. They don't get paid. They get their expenses paid. So
how is that work? If the employees are federal, why isn't it government through and through?
But that's the problem. That is the drift that has taken place, because in the establishment of the Smithsonian, it specifically says how the bequest, the funds given by James Smithson, should be used to pay for the secretary and the officers of the Smithsonian Institution. So this is the whole other mess that has happened. And it's probably why there is a reluctance, has been, by the Supreme Court to do anything, because it's such a unholy, illicit union that they will have to tear it apart and say, this is really what it is, and change a lot to bring it into private charitable. And that's what when you read that, the investigation 2007, that's what they said. They said this is a mess and it needs to be fixed and they gave recommendations, and it needs to happen again where professional, private, charitable trust individuals look at it and say, yeah, this is the line that needs to be drawn. That's the Supreme Court needs to draw the line between the private and the federal government.
Now, your argument is if they don't, they open themselves up to more meddling by the Trump administration. But if they do, they may all lose their jobs as regents.
They're all going to they should all be booted out because they breached the trust. They breached it. Their whole life. My lawsuit is against the Board of Regents. It's against John Roberts. It's against Lonnie Bunch and Dr. Richard Curran, who was part of the people that booted me to the curb originally, completely trampling the trust beneficiary rights, completely violating the duties of loyalty, the duty of care, the duty of impartiality, the duty to document they have a administrative duty. They trampled the whole thing. So he's involved. So now it's those folks plus Congress. For breach of trust of inaction, there is a duty of action for trustees to act on behalf of the trust. Congress has sat there silently while the president is meddling. They should have come out and said, this is in the realm of Congress. The legislature has nothing to do with the executive. Hands off until we resolve what's good. They've done nothing.
They don't want to touch it. It's a hot potato.
A hot potato. And then the president, for his overreach, and now the trust law crime is called I love it. It's called a son de tort. S-O-N, it's a French term, obviously, S-O-N-D-E-T-O-R-T. It's a son de tort crime where a non-trustee meddles in the private trust of somebody else. So it's going to be fascinating if finally the trigger is pulled to cause this legally to be adjudicated at the U.S. Supreme Court. Larry, we're going to find out if I was just a complete nutcase or I was actually right.
Okay, well, we'll stay tuned. Let me just ask you again, if you could say the name of your book, because I don't have a copy.
Odious and Cerberus, An American Immigrant's Odyssey and His Free Speech Legal War Against Smithsonian Corruption. And that covers all of these issues. I wrote about all of these issues. They were all documented in there. And now, interestingly, as we know, I'm stuck in it still, and they are all coming to the surface again. So,
where can people get the book?
Amazon, Barnes & Noble, anywhere that books are sold, you can get it.
Does any library have your book?
Right now, I doubt it.
Does the Library of Congress have a copy? Did
Probably.
you give them 2 copies for registration?
No, you had recommended it at one point, which I thought was a good idea. I just, at this point,
Well, you send them 2 copies, so at least some members of Congress can read your book when they.
Well, I've sent it. I sent the book out to members of Congress. To me, I think right now, until somebody actually says, no, hold on. The first point was what happened in June, which I said when Maura Judkis from the Washington Post said, as much as there's all this eye rolling about Julian Raven, they said, he does raise a legitimate question. And it was the first time somebody actually acknowledged that. And then she went into it, trying to answer those questions and say, these are unanswered questions. So that, if they come out and write a story now, especially with A.G. Schwab, you see, this part is so wonderful right now because
it's a local story as well as a national story, as well as a cultural story, as well as a political story, as well as an institutional story, as well as a financial story. Let me ask you a question. Lindsay Halligan, special assistant to the president, who is apparently working this issue, her signature. Have you ever talked to her? Or
I've emailed her a couple of times, never responded, so I don't bother anymore.
What about Vince Haley?
No,
Assistant to the President, Director, Domestic Policy Council.
No, I didn't. And I would be
one more. Russell,
over there. Don't forget, Larry.
Russell Vaught, Assistant to the President and Director of the Office of Management and Budget.
No idea. No idea who they are. And
they haven't. Nobody's talking to you.
No, because I'm anathema to them. I call the president to resign.
What do you get out of this? Let's say you win.
Well, I've asked what I've
Do
asked
you
for in
get
the
any
lawsuit.
money?
Yeah, well, I've asked for various things. I've asked for the fair adjudication of my portrait once and for all, according to Smithsonian established written standards and procedures of portraiture consideration. That my painting
Okay.
get its due day in court, basically, and that they give it a thumbs up or a thumbs down based upon their standards. That they give me that's one thing.
Well, it certainly has historical merit now because it's
Right,
been the
but
center of all this litigation.
but I wrote to them. See, when I applied in the beginning, at the end of 2024, I applied to say it to show it again. I wrote, now that the Smithsonian itself is part of the historic record in order of the litigation, it validates my painting even more so to become a story at the Smithsonian.
Okay, but so okay, and what else are you asking for?
And obviously, I'm asking for compensation. I didn't put a dollar amount. I said whatever is fair in the minds of the
But
court.
in
Or
other
the
words, are you
jury.
keeping track of all the hours you've worked on this?
10 years,
And
10 years of my life, Larry. This is, this.
okay, but you have to have the receipts, as they say.
Well,
You got to make a timesheet.
well, that,
So
that that might be something I have to do, which I obviously
yeah.
would do if I had to. But it's consumed my life for many years. Last night I was
It's the
watching.
equivalent of legal fees, right? You're doing it all
Oh,
yourself.
compensation. I'm asking for punitive damages against, and this is a rare thing to be granted against charitable trust, but it's not impossible. It's happened in the past because it puts trustees on notice about breaching trust to take the trust duty seriously. Punitive damage, 10 years, and when they have admitted. Now, when Lonnie Bunch came out and said, yeah, we've been partisan, you admitted to what I sued you for, and you've done nothing about it. You never called me up and said, Mr. Raven, we're really sorry. We'd love to just, take this conversation again and consider your portrait and do, absolutely nothing. And so you'll admit to committing the crime and yet leave the beneficiaries of the trust wounded and injured, having their rights silenced because you don't have the within you to contact them and do the right thing. Forget it. Now you need to be put.
But you're not asking to be made director of the National Portrait Gallery.
No, I don't know. No, absolutely not. Absolutely not. I am not an administrator like that. That's not my thing. I would be happy to participate in any conversation that could help bring it back to its right standing. And I wrote a blog about how should we deal, like, for example, and this I wrote about in my book, which is when we deal with controversy in the increase in diffusion of knowledge. The president's absolutely right about what he's poking the finger at. But instead of trying to remove one and do the other, I think all subjects of controversy should have two sides told at the Smithsonian: equal square footage of space over 10, 50,000 words or whatever. You can put this is the for and this is the against argument. Here's the portrait. Here's the individual. Here's the subject. Here's slavery. This is what these people are saying. This is what these people are saying. Let people go in, read both sides, and walk away and make a decision what they believe. Maybe
well, that's the way I was brought up. That was the American way. Somehow it seems they've adopted the Soviet way of a party line instead.
Yeah.
And I don't know how that happened, but
it's crept in, and it's been the truth in the Smithsonian, and I think that's the only solution, and rightly so. That the president's side, yeah, let because I said this in my lawsuit. I said, the Smithsonian could have a Russian National Museum in Washington D.C. There's no prohibition on knowledge. It doesn't say what it can or what it can't do. So what we need to do is present it in such a way that, yeah, there are two sides to this story. America has this very split personality about this story or this issue. Tell both sides, give them equal footing. No one's getting more space or time than the other person. You tell your side. I think that's the answer. And then let people go in, see it, walk away and say, well, I've heard both sides. I'll make the decision myself. I think that is an honor to the increase in diffusion of knowledge.
And also you would increase the number of people who would attend.
Both sides would be represented.
Yeah. All right. Well, it sounds very good to me. Good luck to you. I hope that you get your day in court finally, and they don't duck the issue as they have. And maybe the fear of if they duck it, Trump taking it over might scare them into actually doing something.
You're absolutely right. And I thought about that as well, because they say, well, what are the consequences if we don't? And that's exactly somewhat. There are going to be some heads are going to be either decisions that the judge makes or the attorney general in supporting this case will cause potentially heads to roll, and they're going to have to say, but for the bigger picture, those people are going to have to pay for it because you know what, they admitted to committing the crime anyway. So tough luck.
All right. Well, God bless you,
Thank you.
and good luck with your efforts. And I look forward to future updates as this moves forward. And we could just say the name of your book one more time.
Odious and Cerberus, an American immigrant's odyssey and his free speech legal war against Smithsonian corruption.
And that's by Julian Raven, who has been our guest today. Very interesting guest. And I wonder if we'll get any feedback on this one. And thank you again. And hope to talk to you soon and have some fascinating updates. All right.
Thanks, Larry.